So to give you, again, an example, we started seeing in the basically the mid-90s, late 90s, you started seeing NAFTA has investor-state dispute settlement in it, the North American Free Trade Agreement. Very powerful agreement, includes, Mexico, Canada, and the US, but especially Canada and the US are both very well-developed, complex, well-respected democracies with well-respected judicial systems. You started seeing these disputes arise between these two countries. So at some point in the 90s, California passed a law outlawing a chemical that was leaching into people's groundwater and polluting the drinking water. They said, we can't have that in our state. Canada, this Canadian company that made that chemical, used this investor-state dispute settlement clause to challenge the California law and saying, that's not treating us fairly. If you pass that law, we can't sell our chemical in California. That's not fair. This is an actual case. And that no longer gets to the point of going back to that history of corporate, of why we have this case in the first place, or why we have investor-state dispute settlement in the first place, was to protect the actual property, the destruction of a factory, or a country takes over an oil field, something like that. All of a sudden it's like, we can't pass a law designed to protect groundwater without getting one of these cases. And that actually, because it went to a tribunal, then all of a sudden you see, you actually, and I interviewed all these people. This is one of these fascinating things. It went back to the 1990s, early 90s, and spoke to a lot of these lawyers who were operating at the time. And I said, what did you think of ISDS? What was this tribunal? And they said, I don't know, we never heard of it. It was never discussed in law school. 80s, 90s, it wasn't a topic. And then all of a sudden in the 90s, you actually see this click, and people say, whoa, if this country passes a law that I disagree with, or that I think is unfair or inequitable, then I have a route to have a binding arbitration with a sovereign nation. And so to give you another example, just recently, as of January of this year, a Canadian company, TransCanada, which was the company that was going to build the Keystone XL pipeline, they decided that it was unfair for the United States to cancel the Keystone XL pipeline. Obama's executive decision to cancel that was a violation of the North American Free Trade Agreement, according to this company. So just start thinking about that. How does this put us, how do we make sense of that in the future? How do we pass laws that other countries are going to think is unfair? The one that got talked about, another case that got talked about a little bit on John Oliver's show, what's it called, last week, this week? Last week tonight. It was Philip Morris, the tobacco company, used this provision embedded in a trade agreement to challenge Australia's decision to make it more difficult to pass stricter anti-smoking laws in Australia. Australia passed a law, their Democratic Congress, Parliament, passed a law saying you have to cover the packages of cigarettes in stores. And the idea behind that was to keep children from buying more cigarettes. Philip Morris said, that is unfair to us. It's a violation of this investor-state dispute settlement provision. It's a violation of that tiny little paragraph that says you must provide fair and equitable treatment at all times. This went all the way up. This was an actual tribunal that lasted for more than a year. So that's where we are today, and that is one of the reasons why this court system all of a sudden is being written about in the New York Times all of the time. So you saw this explosion of cases. You saw this all of a sudden it wasn't about the destruction of physical property. We're talking about something totally different. We're talking about the manipulation of language. We're talking about what it means to be fair. We're talking about who's fair to whom. Are we talking about fair to the children who aren't smoking in Australia? Or are we talking about fair to the bottom line of Philip Morris? And that is one of the reasons why we have this political backlash right now. And this is only happening really on the margins of our discussion. But when it comes to investor-state dispute settlement, it's one of these incredibly contentious moments buried in trade agreements. And you have the conservative lawmakers, the Jeff Sessions of the world, who are very, very concerned about it because they see it as an imposition on U.S. sovereignty. If that Canadian company can sue the U.S. outside of U.S. court systems, that's an imposition on U.S. sovereignty. You have the liberals, you have Elizabeth Warren and Bernie Sanders out there really concerned about this thing too because of the regulatory issues. If this means that we can't pass environmental laws and public health laws, what does that mean? Or if it means that we could be challenged for these laws, that's also a problem. And then you have the libertarians somewhere in the middle who are also concerned about this, which is kind of an extraordinary thought. Libertarians are overwhelmingly free trade, overwhelmingly free market, and they also think that investor-state dispute settlement's a bad idea because they see it as a public subsidy for foreign investment. And that takes us back to where we started off, which is that from the very beginning of civilization, investing abroad has always been risky. It's always been super risky. You always risked losing everything, having all of your wares stolen or being summarily killed by some foreign leader. You don't risk those same things anymore, but now if you want to go invest in China, or you want to go have an oil field in Venezuela, those are major risks. And these corporations get together and they game out those risks. But the question is, should we have a court system? Should we have a private tribunal system that protects, that provides U.S. or taxpayer dollars from any country to subsidize those risks? And that's kind of the libertarian argument against this. So I want to get into other questions about trade and where we are in terms of this discussion of trade right now. I'll just give you a few top-line thoughts on that, and then I also want to make sure that we get enough time to open it up for questions and more details about how this tribunal system actually works. So if you're totally confused, just hold on to those questions. But getting to the free trade agreements now, we're in such a fascinating time. I think that all of us, it would have been unheard of 5 years ago that both the Republican candidate and the Democratic candidate are anti-free trade or against the Trans-Pacific Partnership in this case. It's just an extraordinary moment. And then we have over in Europe, we have the British who are voting to remove themselves from the European Union. You know, we're in this moment, this extraordinary moment of reactionary isolationism, fear of globalization, and there's so much of this going on that investor-state dispute settlement is this one tiny little aspect of that. But it has nothing to do with free trade. And that's kind of what I want to conclude on, that if whatever your thoughts are about free trade, whatever your thoughts are about globalization, whatever your thoughts are about whether investors should have protections abroad, you can be 100% in favor of all of those things, and you can still be concerned about this tribunal system, this shadow court, as I call it in the book. You can be concerned about how that exists and how it unfolds and why it exists the way we have it now.